Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
All right, we're here with my good friend, Lloyd Bell. And Lloyd's been a part of Trial Lawyers University since the very beginning. You know, Lloyd and I didn't know each other in March of 2020 when the pandemic came along, but the guy that runs CBN suggests, hey man, there's this great lawyer down in Atlanta that you should connect with because he's got lots of trials on our network and he's doing a pretty good job. And that's how I met Lloyd Bell. So welcome back to Trial Lawyers University, Lloyd.
Well, thank you, Dan. It's good to be here. Yeah, I have a little bit different memory of how we met. This was, if I could just share it. So we were out in, I had moved out to the lake during the pandemic. I was working out there, and I kept getting these emails from this person named Dan Ambrose, asking, let's talk. I want to talk to you. And then you called me. I didn't know who you were. And I was like, God, who's this guy who keeps calling me? And
Stalker.
a little bit, yeah, a little concerned,
Right,
but,
and rightfully so.
But I finally took your call, and it was the beginning of a good relationship. You told me what you were doing, and we got to know each other. And what sort of struck me is that you were doing something different. You were going to lean into the sort of downtime when all the courthouses were closed, and you decided to just become a teacher and provide really good content to lawyers who are stuck at home, stuck in front of their computers and not doing what they wanted to do. And it got my imagination, and I was glad to be a part of it.
Well, I'm glad you were too. But as more of the, I actually really became the student and recruited a whole bunch of teachers to, teach me and teach the trial lawyers community throughout the country in general. But I always call myself, student at ground zero, student one. Student one. I didn't, I mostly did this for myself because I want to learn all this stuff, and I know everybody else needs to know it. But there's so much to figure out if you want to become a great trial lawyer. That it's crazy how much study and learning and constant. I know they call it the practice for a reason, but I think people don't really get how much they have to train and learn to become a great trial lawyer. I mean.
Yeah, that's exactly right. And one of the benefits that you provided to me, I can't speak for all the other folks involved, but is you provide a lot of focus because you're diligent about your schedule and about staying on top of folks to turn in their materials and to appear and to participate. And that's good for me. I need that kind of structure in my life. I always struggle with time management like so many of us do, but it's been very helpful to kind of have you as kind of a coach in that respect, and just the process of preparing to teach other folks makes you kind of reevaluate what you're doing and think about it in a different way. You're not just reacting and doing your practice, but you're slowing down and thinking, and that's I've found that very helpful.
Yeah, I mean, I can imagine because. It's one thing to be doing, but it's one thing when we have to explain to somebody else why we're doing it. And it makes us rethink it, reanalyze it, and say, yes, I'm doing this for a reason. Or no, I got to make this adjustment right here. Now that I've thought about it, I think this would be a better way to do it. And that's how we constantly evolve. Well, Lloyd, when did you know that you really first wanted to become a lawyer?
You talk to folks who were like, well, I knew when I was, a baby that I wanted to be a lawyer almost. And I was joking with you earlier that my whole life I've heard that I should be a lawyer. But usually when people told me that, it was meant more as an insult and a put down than it was as a encouraging comment. I'm the youngest of 5 kids, grew up in a very rambunctious, dysfunctional, Hunger Games type of environment. And it became really important to be able to think on your feet and articulate your position or you would get consumed. So I learned early on how to support what I'm saying, stand up for myself, stand up to bullying sometimes. So I had those tools, and unfortunately, I took those to school with me, and grade school, and would argue with the teachers and argue with other people, and sort of had that in my DNA, I guess, at a young age. But you asked when I decided to become a lawyer. That came later. I was pre-med. I'd always been interested in science and done well in the science courses, so I liked that path. My dad was a doctor, so that just sort of seemed the natural path to go, and got into the pre-med program, met these two courses called Organic Chemistry 1 and 2 that discouraged me from continuing in my quest for pre-med, and I just decided this was not my path. I didn't like the isolation of lab work, and I didn't like the isolation of science at that level, and I was really drawn to my liberal arts classes. So in college, I started pivoting and thinking, this might be a better path for me and for my skill set.
And where'd you go to law school at?
I went to Mercer, here in Georgia, Mercer University. I had a commitment coming out of undergraduate to serve in the military. I went to Virginia Military Institute. And at that time, if they gave you a commission, they call it, they offer you a commission, offer it with no choice but to accept it, you had to serve. And I got commissioned into the military intelligence branch of the Army, which was a longer commitment, but my future lawyer skills coming to bear, I lobbied for them to allow me to defer my commitment until I went to law school, but then I'd owe them an extra year. A little bit complicated path, but basically I said I'll go in the Army after law school and go into the legal branch. So the Army sent me to Mercer, and when I graduated, I spent 4 years in the Army JAG Corps, which is, I tell people, it's like a big DA's office because you get a lot of experience trying cases in different parts of the world. And then I also did, which was my favorite, I did the defense work, criminal defense work, and defended soldiers who got in trouble. We used to say, defending those who defend America. That was our motto. Absolutely, absolutely. So
actually, I was actually at Mercer Law School in 1996 because I did the National Criminal Defense College down there.
Yep. And you probably met some of my professors. Mercer's very well known in the criminal defense community. They've got the college you went to. I know Kent Spence went to it, and others. But it's put out a lot of very strong trial lawyers, criminal defense lawyers.
So you spent your first 4 years as a lawyer in the Army JAG Corps, is that right?
That is correct.
And how do you think those 4 years helped you really become the trial lawyer you are today?
Well, I knew I wanted to do trial work when I was in law school. I was drawn to all the mock trial and moot court teams, and enjoyed the kind of competition of it. So I was sort of drawn to that naturally. But once I got into the Army, it's a great environment because the more responsibility you want, the more they are willing to give you. So you can be a very young lawyer, and if you want to take on the bigger cases, the more senior officers who are more management types are more than happy to let you do it. There's no money at stake, which is sort of like the DA's office. It's not a money issue. So if you want to get in there and try a lot of cases, they are more than happy to let you do it. And I ate it up. So I got to try a lot of important cases at a young age, which is hard to do in this world. But I was very grateful and fortunate.
And so after you get out of the JAG Corps, where do you head to from there?
So I got out, and through word of mouth, I learned that this law firm just outside of Atlanta, up in Athens, Georgia, which is, of course, the University of Georgia, one of the biggest firm in that area, needed a litigator to handle a bunch of sort of spin-off litigation from real estate developments and other issues. So I went to a more traditional law firm. It was a defense firm at the time, but then the founder of the firm got interested in plaintiff's work and brought me along to start doing medical malpractice plaintiff's work. We had been doing some medical malpractice defense work and other litigation, but he brought me along and said, we had a few cases to work on, and it got my imagination. We started traveling to take depositions and to meet with experts, and it just fascinated me. And that's where the urge came to do this kind of work. And then I moved back to Atlanta, still stayed with Big Law for another year or two, and then started my own firm back in 1999. It was our 25th anniversary this year.
Wow.
Yeah, I know it. When you say it out loud, it kind of takes your breath away and makes you cough. But 25 years we've been doing this. And I haven't been doing med mal that whole time. I like to joke that we started off in the threshold law business, taking basically any case that came across the threshold. In fact, one of my earliest cases, I tell folks, it's a true story. One of my earliest cases, I had just put up a website, which was pretty cutting edge back in 99, 2000. I mean, people were just starting to do it. And I got my first lead off the website. And there was this person who worked at a financial investment company who had bought a little bag of Lorna Doone cookies from a vending machine. And he found out that there was a worm in his bag of cookies. And he called me up and he wanted justice. And I was, again, doing threshold law. So I said, well, I will get you justice for your half-eaten worm in the cookies. And we got him a $400 settlement. So I was very proud of that.
Yes, and you remember it 25 years later.
I do.
The beginning of a very fruitful career.
It has to start somewhere. And I tell that story because you can't be too proud to take cases if it's even not the biggest case in the world, but legitimate. And, you learn on stuff like that. So I learned some lessons. No more cookie cases, though. Don't take those.
Lloyd, you were really evolving with your, case selection. Because that's what you're about to talk about. And I know you'll be talking about case selection in your master class in Huntington Beach, because it all starts with case selection. But let's talk about that, Lloyd. You've been really focused on medical malpractice for a long time, and most of the cases, almost all the cases I've seen and talked to you about have been medical malpractice. I know you do a few big falls here once in a while when our friend Big Fall Bruce, he's ready for his case to go to trial.
Yep.
But on the medical malpractice side, because we did a program last September in New York City, and you taught a 2-day master class there. And that was, by the way, that was recorded. And so if anybody wants to access to that, it's on TLU On Demand. And where we also have not just Lloyd Bell's masterclass, but all the conferences we've ever done, both in Vegas, Huntington Beach, Marina Del Rey. They're all been recorded and are up there, as well as we've done, I think, 370 webinars. Isn't that crazy?
Holy cow. That's a lot.
I know, that's a lot of webinars.
That's a lot of webinars.
But people keep getting verdicts. We got to keep talking about them and keep learning from them. And so that makes it pretty fun to keep. Especially when somebody gets their first 8-figure verdict. That's always an exciting day. My buddy just had that happen after 25 years or 30 years in practice on a motorcycle case. So he's going to be coming to Huntington Beach and talking about it, Jason Wechter. But this is the second time you'll be teaching this medical malpractice masterclass. So first, tell us what is going to be happening. And this is going to be on June 7th and 8th, Friday and Saturday, in Huntington Beach. So tell us what day one is going to be about.
Right. So day one, we've got a number of different topics we're gonna touch on. I've been sort of intentional to sort of bring in things we've learned over the past year, and we're going to start off sort of at a higher level and talk about some themes that make people successful in medical malpractice, things that lead to good results, both in settlement and in verdict, obviously. So we're going to talk about the philosophy of medical malpractice, the mindset that you have to have going into it, because it is different than a lot of cases, the other cases, car wrecks, trucking. There's a different philosophy to it, and it's not a hostility towards hospitals or doctors, it's not driven by anger, but there is a specific, I believe, a mindset that you have to get yourself into to be successful. So we're going to talk about that, and then at a more granular level, we're going to talk about some of the details that help you advance your case, the kinds of things you want to do in pleadings, the way you want to approach depositions, expert depositions. And one of the things we're going to do differently, or I'm going to go into that I did not go into in New York, but I think it's very important, is the structuring of the actual trial in terms of witness order, and even with specifically to the witnesses, how do you want to structure their examinations? When do you get a witness off the stand to get in front of the jury to participate in some demonstrative exhibit? Have them teach. Do you ever get the defendant off the stand? Sometimes you do. We'll talk about that. So we're going to get into some real nuts and bolts, down the weeds, so to speak, but we're also going to be high level, and we're going to talk about themes and demonstrative evidence and things that will help drive the case. One of the big themes, though, this year that we did not address in the detail last year is going to be the concept of system error, system failures, and how a medical case in today's environment particularly needs to be structured as a systems case, not a nurse who makes a mistake or a doctor who doesn't cut the right way, but you have to look at your cases as systems cases. And one of the guests who's going to be participating on both days is a good friend of mine, John Burroughs, Dr. Burroughs, who is a system failure expert. So he's going to present on system error on the first day, and on the second day, we're going to set aside time in the afternoon for people to bring their cases, their actual cases, and when I say bring their cases, be prepared to talk about their case in some detail. And then Dr. Burroughs is going to help the participants reimagine their case as a systems case. So you might not even think that's possible. Well, how is this a systems case? But he'll help explain that part. So it's going to be very interactive. It's not just going to be a lecture format. It's going to be a lot of dialogue. It's going to be audience participation and involvement. So I'm super excited about it. It's going to be a lot of fun.
All right,
and it's Huntington Beach, so you can't beat Huntington Beach. I've presented there with you before, and it's just the best venue in the world.
Well, it's going to be a very different program than the one you were at 2 years ago. Let me just tell you that, because when you were at that one, we had maybe 200 people there, and we just had a little space there. But this time we got bought out the entire hotel for the whole 5 days, and there's almost 600 people coming right now.
Oh, that's great.
And I think there'll be a few more registering in the next 2 weeks. It's going to be we have live music every night, theme parties, food trucks, and the lobby is going to be a gaming lounge. We got a couple ping pong tables, air hockey, foosball. It's going to be an open bar every night in the lobby till 11 o'clock. It's going to be so cool, Lloyd.
Another ping pong tournament this year. You going to get that organized?
Oh, it's on, baby.
Excellent.
It's on. It's going to be. I have a lot of work to do in these next 10 days, but I'm super stoked for it all. Day two. I know we talked about day one. You touched on day two a little bit. What's going to happen, but on day two, what's that going to be covering?
Yeah, I think the most interesting part of day two will be the audience participation and involvement. So folks who have medical cases, and they don't have to be a pure medical malpractice case. Some people might be, the lessons we're going to be teaching in the strategies and tactics we're going to talk about, they're going to translate it into other serious injury cases. It's not purely medical cases because, of course, you take depositions of medical experts in any injury case, obviously. But day two will be a focus on understanding your case as a systems case. That's a big part of day two. They're also going to talk about some of the basics in trial that we've learned, frankly, from the past year. I've had a number of trials over the past year. I'm going to bring one with me to talk about and some of the lessons I've learned. The use of Zoom, for example, is one new point that we're going to be talking about. And I don't know the rules across the country, but at least in Georgia, it's becoming commonplace to call live witnesses by Zoom to testify. And it's a very practical change. It helps with scheduling, but is it persuasive? And what's the feedback we've been getting from juries? We'll be talking about that, talk about focus groups, and we're going to have an open forum in the afternoon, as I mentioned, to talk about system issues in the cases. But there's also going to be time for people to bring their questions, into not just sit there as an observer, but to participate and have questions answered. So the goal is after the 2 days, when you go back to your practices, the goal is that you'll have an enthusiasm and an excitement and a collection of new tools in your toolbox to bring to your court and to hopefully lead to good results.
And a whole new group of friends that are focused on a topic like you're focused on it, because one thing that kind of drives me on doing these type of master classes is that when you get a bunch of smart people together who are focused on the same problem, like the solutions they can come up with as a group, I think dwarf what somebody could do by themselves. Just
No
with the
question about
creativity
it.
of the ideas and the just the interplay and the energy that's put into it. So I think that's another big benefit of doing these classes.
Yeah, I was joking around recently I was at a happy hour for some attorneys. We were joking that the most common sentence you hear at these events is, "Let me tell you about this case," or "I've got this case."
Right.
I mean, lawyers are just drawn to stories. I mean, just like jurors are. We want to hear a story, and it's not always the best story or happiest story, but we're drawn to stories. And to your point, there's just no better group of people than trial lawyers, and we care about each other. We care about helping, and it's just the community is so valuable.
Yeah, whenever I hear somebody say, "Well, I don't when I ever hear a lawyer saying I don't like being around lawyers," I'm like, I don't know who you're hanging out with, because like they're my favorite people. That's one of the reasons I put conferences together, so I can get a whole bunch of my friends together and get to hang out and kind of have a party and invite a whole bunch of new friends. They don't even know, they're just gonna show up, and by the end of the time, we're gonna have this whole new community, which is gonna be, which is just the coolest thing to me.
Yeah, it's one thing I get. I hear some too. People will complain, say, "Well, they just gave a bunch of war stories." I love war stories because that's how you learn.
Yeah.
And how valuable is it to learn from somebody else's experience? And you can't experience everything yourself. You don't want to experience the necessarily the defeats. So it's good to hear those and understand and learn from them. So
Really, you don't want to build character, Lloyd. You don't want to build. You're not trying to build resilience by getting your
well,
ass kicked over and over. I mean,
you'll
I know
get
it happens.
yeah, everybody has that. I've had plenty of that in my career, and it's still have that. It's just a tough business we're in. In medical cases, and we'll talk about this more, but they're special, and the reputation they had was that they're almost unwinnable. I mean, we heard statistics like 90% are defense verdicts. Very misleading statistic. I don't believe it to my core. I believe that's a misleading figure that's put out by the insurance industry to try and dissuade people from taking these cases. I find that they are incredibly compelling cases. Juries care about them. They don't always rule in our favor, but I can't remember when I've had a jury after a 2-week, maybe 3-week trial act like they were offended to be there. I mean, it's just the opposite. I had one juror at the end of a case tell me it was the most valuable experience in their life. And he meant it. He said, "This was the most valuable experience of my life, serving on this jury." And people feel empowered. They feel important. It connects them to our government, our country, the idea of justice and being able to deliver justice to somebody. Very powerful themes, and people feel so powerless in so many ways. But this is one place where they can give expression to their better selves, and it's beautiful to watch.
Well, let's talk about trial, Lloyd. And I know you recently had a CRPS verdict that was really happy about how it all went out. And what was it? What was that case about?
It was a challenging case. It was a lovely woman, client of mine, who was up on her roof. And then this is not some high-pitched, multi-story. It was a single-story house, but she was up on her roof, patching a hole with some tar or some material like tar. And she misstepped and fell on her roof, and her leg got caught up underneath her, and she broke her fibula, the smaller bone in your in your leg, your lower leg. Went to the hospital. The hospital referred her to a orthopedic surgeon. It was a minimally displaced fracture. So she had another procedure scheduled at a podiatrist, have a little, almost like a bunion taken off. So she called the podiatrist group and said, hey, I'm going to have to miss that procedure. I broke my leg and I've got to go see an orthopedist. Well, the podiatry group pitched her and said, oh, no, we can take care of you. We've got a surgeon here who can do this. We can take care of it. And she, and better yet, we can come in, you can see us today. Come on in today. So she went in to reduce the story a little bit. Surgery goes forward. The surgeon, when he was fixing, he decided to do fixation and screws. He severed one of her nerves in her leg, and it's called the superficial perineal nerve. And we contended that this set up the complex regional pain syndrome. The defense contended that we couldn't prove it was from the nerve or from the fall. That was one of their defenses. And very hotly contested case, a lot of drama in the case, a lot of emotion. And ultimately, the jury concluded that we proved our claim and gave us a significant verdict, a $4 million verdict in one of the more challenging cases I've had. And it was real coin toss what the jury was going to do. But for a couple of really good reasons, they concluded that we had proven our case. One of the most powerful reasons was because at the last visit with the client and the doctor, she had the good sense to record the visit. She pulled out her cell phone, pressed record, stuck it down beside her. And the reason she did that was so she would be able to understand what the doctor was saying. It wasn't any nefarious reason, but she's not a medical person and she wanted to make sure she didn't miss anything. Well, as it turns out, the doctor completely put different information in his medical note than what she had recorded. She had reported burning pain, stabbing pain, all these issues, none of which made it into his note. And he just said, oh, she's progressing well, she's improving. And the jury found that really was a blow to his credibility and made a big difference, I think, in getting the verdict we did.
All right. Well, in this particular case, I just want to talk to you about some of your processes in regards to trial in reference to this case. So 90 days, 90 days out from trial, what are some of the things that you're doing to make sure that when the day comes, you're trial ready?
The 90 days out, I'm already thinking about demonstrative evidence. I'm thinking about how we're going to teach the case. Of course, on the paralegal support side, you're doing things, you're making sure your witnesses are lined up, and there's a lot of sort of procedural things you're taking care of. But on the lawyer side, I'm really focused in on preparing a good timeline, a good physical timeline. And I'm working on demonstratives, and I'm storyboarding how I'm going to put the case together. And almost always it starts with the timeline. And I can't overemphasize how important that is, because there's a lot of information coming at these jurors, and you need to be thinking in terms of demonstratives to help them organize the data. So they're not just being overwhelmed with dates and times. But the timeline is incredibly important. So that's one of the primary issues I'm focused on. I start working on my exams. I start deciding on trial structure. Who am I going to call first? So those are some of the sort of the main things I start working on. Now further than 90 days out, I'll review the depositions again. I try to annotate my depositions as soon as I get the transcript in. I don't wait until later to do that. So I'm sort of ahead of the game a little bit in that respect. But those are some of the major things I start working on.
Okay. Well, speaking of timelines and how important they are, do you have any program that you use, or any way you do them? Do you write them on a flip chart? I mean, what's the way you found best to put your timelines out there so the jury can follow and learn?
Well, the timelines I'm talking about for trial are demonstrative. So I have a professional company that puts those together for me. Because a lot of things matter in a timeline. I mean, just to back up a little bit, the importance of a timeline is not just to collect data points. The value of a timeline is to show relationships of time. That this happened before this, that this happened a long time before this, that this happened a long time after this. So it's to show the relationship. So it's not the same kind of timeline that we would use or that we do use for the medical records, for example, all the medical care, which is a collection of data. But the idea is to help the attorney see and understand the data so we can discern what's important and what's not. Interestingly, one of the topics we're going to talk about in Huntington is about AI and the application of AI into our medical malpractice world. And it's coming. We're already using it in some limited ways, but the promise is that it's going to be even more effective in helping to develop timelines and those types of things. But I digress. So I use you asked about programs I use. The main program I use, which is a free program, is called, I'm pulling it up here, make sure I get the time. It's called time.graphics. And it is very powerful. And gives you all kinds of tools and ability to compress the time scale, colored boxes, tags, very powerful. I use that for my own internal preparation. Sometimes I'll make a screenshot and print out part of it to use at a deposition. That can be very helpful, but it's not what you use to actually present in trial. It's just not designed for that. It wouldn't be good for that. But it's very helpful to visually put together your timeline in a way that you can use as you're preparing the trial or preparing the case for trial.
All right. And so now as we approach trial and as you think about your voir dire, and especially the voir dire in this particular case, tell us about your approach to the voir dire.
Well, it all depends on what the judge's procedure is. As you know, you gotta follow the rules that the judge is going to.
You got that darn judge up there.
Yeah. So my preference, and most judges allow it this way, is the general question followed up immediately with the follow-up question. So you ask a question out to the group. Anybody ever served on a jury before? And you get 5 or 6 hands. The ability to follow up immediately is very important. So I call that sort of the open format, or I used to call it the Phil Donahue approach. And then some of these judges are a lot younger than I am, and they didn't know who Phil Donahue was. So that's not the best example anymore. Or the Oprah approach. You want to be able to get the jurors talking, and you want to encourage crosstalk so that you can start seeing where the divisions are and where the groups are being formed. So, for example, I might ask people's views about medical malpractice. Some folks think medical cases are harmful to our country, harmful to our community, because they can cause hospitals to shut down and doctors to leave their practices and go someplace else. Other people feel differently. Other people think that medical malpractice cases do have an important role in our society. Which way do you lean is always a good way to kind of get people. But then once people identify themselves and say, I just think these lawsuits are bad for our country, super important, and a lot of commentators talk about this, but super important to honor the answer no matter what the answer is, and not to show that you're trying to push people off of their opinions. But then I'm looking for people to express themselves. So I'm trying to give them a safe environment to do that. And then once they do identify a strong position, and I've honored it and thanked them for sharing it, I'll look for other allies. Well, how many other folks feel the same way? And then if I don't see any movement or I see people trying to shut down, I'll call on them without warning. Say, Miss Johnson, we hadn't heard from you in a while. Tell us a little bit about your thoughts on this topic, whatever the topic is, and just draw people out. And then once people realize they can be called on, of course, they're leaning forward and they're sitting up straighter and paying closer attention, because you're really accessing the one factor that is most worrisome to people, which is public humiliation. And nobody wants to be called out and embarrassed. And it's just human nature. So So those are some of the tools I use, but I'm really just trying to get people to reveal themselves. I'm not, and at the same time, I'm also trying to gently educate on some of the issues that they're going to hear. Not to get them to prejudge the issues, but to get them familiar with the issues. My friend Sari de Lamott refers to this as providing context. So, before I start asking these questions, this is a case involving a stroke, for example. So I need to ask you some questions about your experience with it. This may touch on some personal matters. I might ask you about your medical condition, your family. So you want to show that you're being sensitive to that. But if people know why you're doing things, they're much more, and they understand why you're doing it, they're more willing to participate. But if you start asking random questions, it's like, why are you asking that? Why are you asking that? You get resistance. You're trying to reduce the resistance and get people engaged.
So you're speaking of your friend Sari de Lamott. She was going to come to Huntington Beach, but unfortunately, there's a Mother's Truckers conference in Vegas that starts like on June 5th. You know about that?
I do. I'm not well, but I know I've heard about it.
All right. Well, unfortunately, they have bad timing scheduled at the same time as TLU Huntington Beach. So a lot of the folks that are going to that would be in Huntington Beach, like Natanya Brooks and a few other folks. And so, but she is going to be coming to Vegas for teaching it in Vegas in October, because that's October 16th through 19th at Caesar's Palace. So that one, Lloyd, you really better have those dates set aside, because that one is going to be the big kahuna of trial lawyers events of the 2024 year. That I can assure you.
Yeah, that sounds good. I'll make sure to get that on my calendar. You mentioned our friend Natanya Brooks. Natanya and I are actually trying a case together in September. I've asked her to co-counsel with me, and we're gonna try this case a different case in September. So I'm excited about that.
Wow.
Yeah, she's a great lawyer. She's interested in doing more medical malpractice. She hasn't done as much of that, but she's moving more in that direction. So I invited her to co-counsel on this case with me, and that's another topic we'll be talking about, as well as the importance of good co-counsel and what you look for in a co-counsel, because it shouldn't be automatic. It shouldn't necessarily be the person who brings you in on the case as your trial co-counsel. It's a very important role, and if you're working with the right person, I've worked with some great co-counsel. Laura Shamp is another one, is one of my favorites. You have real chemistry, and the jury sees that and appreciates that. You get the wrong co-counsel, where you're fighting with each other, and you've got different voices, and there's dissonance, then that can be negative in the trial, obviously.
Can be negative?
Well, it is negative, and it can have a bad effect on the jury.
It's and a bad effect on you for those 2 weeks you're there when you want to kill the other person. So I've been there. Just reach out and choke them.
Yeah, well, I've been there too. I tried a case years ago with a close friend of mine, and we both obviously were much younger, and the jury couldn't keep track of our names. So they told us after the trial was over, we're allowed to talk to the jurors. They told us, they referred to us as the blonde frat boy, that was me, and the brunette frat boy, that was the other guy. And neither one of us were in fraternities or active in fraternities, but that's how they thought of us. Frat boy 1, frat boy 2. So chemistry is important.
Chemistry is important. Now, on the voir dire, so did you talk about CRPS in the voir dire?
Yeah. Oh, yeah.
And so
yeah.
What's your, because I think I believe that like the voir dire for CRPS, traumatic brain injury, depression, anxiety disorder, PTSD, like all those voir dires have a very similar structure, because they're all like invisible injuries.
Right. They're all challenging, and they're not familiar, particularly CRPS. I mean, it used to be called RSD, reflex sympathetic dystrophy, but these aren't, these are relatively rare conditions, and they're horrible, but there's a lot of education going on. People know about stroke, generally. People know about heart attack. People understand, those kinds of conditions, but chronic pain it's a very hard thing to teach. It's very hard to get people to appreciate how serious it is. And there's a lot of room for cynicism. And the defense counsel will typically surveil people who have CRPS. They'll have secret people out there taking videos, showing them using their affected limb when the doctor says, use your affected limb so that it doesn't atrophy and you maintain as much as you can. Then they go and use it, and the defense gets them on video and tries to punish them for it. So, oh, here you are, you're holding a bag with your affected arm. Well, it's not a motor dysfunction issue, it's a sensory issue. And people can use their arms typically, but they just can't touch the part of their affected arm. It's a very strange thing, but they're hard cases. But so yeah, I bring that up in jury selection, and I'm honest about how hard these cases are, and this will be invisible. You won't see it, and then so you're preloading to some extent on the front end. You're providing context, is what Sari would say, but you're preloading and helping to educate the jury on the truth of the case, as well as getting information. So you're not trying to condition them necessarily or coach them, of course, or prejudge, but you want them to understand the context of your whatever the issue is that you're concerned about, and get a discussion about that. You just don't want people up on the talking about these things in jury selection for the first time, and you're not part of that conversation, obviously. So those are some of my goals.
And as far as like money, how do you talk about money? Because, these are very, you have this is a $4 million verdict, but I know you have, you and Laura got a verdict that was like $70 million or something. So how do you talk about money in the voir dire process?
There's the whole 2-day or week-long course taught by another trial group on just that exact topic, asking for the money. How do you do it? There's no easy answer. It's a lot of it. It starts with the rules of your venue. There's some jurisdictions that will not let you ask for or mention a specific number in jury selection. They won't let you ask a specific number in closing argument. Some jurisdictions. And in our jurisdiction, we don't have those restrictions, so we have pretty open forum to talk about it. And what I typically do in jury selection is I won't ask for the specific number, but I'll talk about the range of numbers. If you're asked to be on this jury, one of your jobs will be to decide how much money it will take to make up for the damage and the harm that's been done to my client. So I need to talk to you about your views on that, and then I will say, if the evidence, we're allowed to ask this question, if the evidence supports a verdict of millions of dollars, over $10, $20 million even, if that's the range you're shooting for, is there anybody who just, regardless of the evidence, would not be able to even consider damages at that level? And you'll get a lot of people saying, yeah, that's just too much, it's just too much. Well, in Georgia, they're not qualified to serve. If they can't follow the evidence to a just verdict, then they can't serve on the jury. Sometimes I'll bring in other unrelated cases and say, this is you've probably seen in the news cases where you have big technology companies suing each other for billions of dollars or hundreds and hundreds of millions of dollars for patent infringement or trademark infringement. This is not that case where you're going to be asked to consider those scope of damages of billions of dollars in damages, which you'll see sometimes in corporate America. This is a case involving damages to a human being, and with millions of dollars in medical bills, past and future, and we're going to ask for many millions of dollars to compensate. So there's some conditioning that can go into it, so the jury's they have context for understanding big numbers. And then, of course, if you talk about the big numbers that exist in corporate litigation, it conditions them or helps them appreciate that the numbers you're asking for are not outrageous, especially if you've got somebody who's like in Jonathan Buckaloo's case that I tried with Laura, who's just profoundly disabled. So those are some of the ways I do it. It's hard. I mean, one of my close friends, fellow trial lawyer, Render Freeman, it talks about the personal relationship that you have with money is something that has been formed, since you were a young child. I mean, some people grow up in households where you just don't talk about money. It's rude. You don't ask questions about how much things cost, and those kinds of messages seep in and become part of your personality. Other households are much more open about money and how to think about it and how to earn it and just different relationship. But your personal relationship with money carries forward into trial. And if you've got hang-ups and you've got issues talking about money, the jury will see that and then misinterpret it as either you not believing in your case or there's something they're not being told, which is, those aren't good. You've got to be perceived as 100% credible at all times. So there's a lot of dimensions to asking for the money, and the big one is practicing. That's something new to me, is you actually practice it. And,
Tell us about that. Tell us about
you get in front of people. You get in front of people, and you just like you should be practicing your jury selection. You should be practicing your openings. Every important component of your case, cross-examinations. You got to be practicing your ask for the money and get honest feedback from people who aren't just telling what you want to hear. So, and you stand up and say, I am asking you to return a verdict of $50 million, or whatever the number is. And you'll find that even in that safe environment, it can be hard to ask for the number. You've got to, first of all, you got to believe in the number. But even if you believe in the number, it still feels like you're exposed, and it feels dangerous sometimes to ask for the big number. So practicing helps a lot, because you've got to, when you do ask for it, you have to believe it, and you've got to deliver it in a way that shows you believe it. And if you hide or turn your eyes away or clear your throat or anything of that nature,
or shake,
yeah,
butter, all those things, they make it tough to collect.
I've got another good friend here in Georgia, does a lot of premises work, is an excellent lawyer named Mike Neff, and Mike talks about his struggle to ask for the money with the jury. He'll talk to the jury and say, this is a really hard part of the trial, because if I know that if I ask for too much money, or you think I'm asking for too much money, you'll hold it against my client and say, well, that's just another one of those greedy lawyers that we hear about. But if I don't ask for enough money, then I haven't done my job for my client. My client's trusted me to ask for the right amount of money, and I haven't done that. And I haven't done my job, and I haven't been honest. So that's my struggle, and he shares that with the jury. I've heard him do that before, and it's very effective because it's honest. It's true. And I'm not sure that's the approach for every case or every lawyer, but there's some good good lessons there.
Now let's move on to opening statement. What's your approach to opening statement, and particularly in the CRPS case that we're talking about?
Right. In a medical case, the way I think about opening, structuring my opening, is obviously there are different components to it. It's not a pure narrative storytelling experience. There's some things that you need in a medical case opening that may not be necessary in other types of cases. So the first thing I do is I think of what my hook is. Sometimes I call it the Netflix opening. There needs to be a piece. The first thing the jury needs to hear about, they need to have a hook where they understand what the stakes are. And there are different ways to do that. I've talked about it before. I can talk about it in more detail in Huntington, but you have your hook at the very beginning, and then you identify what the juror's job is, and then you transition and say, well, let's talk about, and he talked about some of the medicine, and I think about the 3 R's, risk. You talk about the risk of what you're doing first, then you talk about the rules to mitigate that risk, and then I'll talk about the right way that it should be done. And one very effective way to do that is when you're telling your story and you get to the point of the story, and of course you generally want to tell it with the focus being on the defendant's conduct. Not start. You shouldn't even mention your plaintiff by name until later in the story. But you start off focusing. If you think of a video camera, I focus the video camera on the moment where the defense is the actor and about to do the bad thing, and then I'll talk about the story. We set the location, the time. We're here at this place, and then walk through what the defendant did until the point in time where he or she makes the decision that leads down the road of catastrophe, whatever that decision might be. Maybe it's not coming to the hospital, to see a patient, and the patient, suffering a horrible outcome. But you take the jury, the story, to that point of inflection where there are two roads that pass, that split in the woods. You can go to the left, you can go to the right. And a very powerful narrative tool is to say, when you get to that point in the road, to say, well, I wish I could tell you a story with a happy ending. I wish I could tell you that Dr. Smith did this and then did this, and looked at the imaging study that revealed this large mass. I wish I could tell you that had happened, and that after he saw it, he would have notified the surgeon, and this mass would have been taken out before it caused brain damage. But if that was the story, then none of us would be here. But let me tell you what actually happened. So now it sets up a nice right way, wrong way. The jury's heard what should have happened, and now they're going to hear the story of what did happen, and they're going to be influenced by the medicine you've taught and the narrative. And when they hear that the doctor didn't show up, they didn't look at the imaging study, whatever the facts are, the jury will appreciate that is negligent. And if only we had gone on the doctors had gone on the right path instead of the wrong path. So that's sort of generally some ways I structure it. And then once I go through the story, I'll have the part of of opening, where I talk about what the defense points are. The defense will say this, they'll say this, and kind of address some of that. And then I'll touch on damages. I don't typically use any visuals at this part of opening. Use a lot of visuals throughout the opening, but not this part, where I'll just sort of pull in closer to the jury and then talk about what this case is really about. And then I'll take it to a different emotional note, which is, this is a case about doing right, making the defense do right by our client, however you want to phrase it. And then this varies sometimes, but generally what I'll do is I'll end my opening, and you'll see why this is a case we're going to come back in closing, and we're going to ask you, because the evidence will demand it, a verdict of, $15 to $20 million or whatever the number is. Yeah.
It's obviously a very detailed structure for, how you approach these cases. And I think that probably helps a lot, because, you start out with a set structure and then you just adjust it and, move pieces around based upon the case. And it makes it a lot easier to improvise when you have that's everybody's like, I just like to improvise. I'm like, well, it helps you have, trained. And so then you can improvise from actual pieces instead of nothing without, people want to be themselves without preparing and stuff.
Well, and you may, I totally agree with you, Dan. You got to have a structure. Structure is story. You have to have a structure. And if you start watching, I call it the Netflix opening, because it just got through my thick head that Netflix is presenting their stories in almost an identical format in every case. They start off with that scene taken out of order chronologically, but it's a hook scene that pulls you in as the viewer. And then once they pull you in, then they'll rewind the tape and they'll start the story, typically an earlier point in time. I'm watching this show right now called A Man in Full on Netflix with Jeff Daniels, and it's all filmed in Atlanta, and it's about Atlanta. It's about a real estate developer who's struggling with near bankruptcy, and people are coming after him. Really, really good show. And in the very first opening scene, it shows him in distress on his floor of his office, kind of laid out on this floor. And then a few moments later, it says 10 days earlier. It pulls you back 10 days earlier. You still have that image in your mind that you can't erase. And I try in my cases to adopt that same story structure where I'll show an image, maybe a video of my client struggling to learn how to walk again, as an opening scene in the case, and no commentary, just let the jury see it and see his struggle, and then fade out, and then move into the rest of the story. And now the jury has that image in their mind, the indelible image of this struggle as they hear the rest of the case, so they sort of know the outcome. Nothing new here. This is as old as the Greek philosophers. This is Romeo and Juliet. They tell you the whole story. Shakespeare tells you the whole story in the first 2 paragraphs. Because tale of star-crossed lovers who are going to die. So you know they're going to die before you ever get engaged with the play, but you still want to watch the play because you want to see how this happens. And I think we have those same capabilities in our storytelling.
So moving on to, like, when you think about structuring your witnesses and sequencing your witnesses in order of proof, how do you approach that?
Typically, I will approach it with the same sort of considerations that are in any drama. You've got to always remember that a trial is a drama, and you only have limited opportunities to really impact the jury before they fade out or get bored or start twitching. So my considerations for structuring witnesses is focused on where will the drama be early, and where's in the medical malpractice case, the conflict, the drama is the conflict between the defendants and me, the plaintiff. It's that the defendants say they didn't do anything wrong, we say they did. So I will almost always call the defendant first in my case. If there are multiple defendants, I'll try to sequence them in chronological order so that the jury can keep track of where the different actors are as the story unfolds. But I'll typically call the first chronological defendant for cross-examination. And it also gives you the benefit of reducing the amount of involvement of the other parties. If it's a one-defendant case, you can call the defendant, and at least in Georgia, the defense attorneys don't get to ask him any questions in our case. So they have to wait until their case and call the witness back. So there's some other advantages to doing it, but the biggest advantage is that this sets the stage right out of the box. This is why we're here. Put the defendant on the stand, and it gives you a number of different benefits. Of course, it increases the drama, but you can also demonstrate your capability of teaching the medicine through the defense mouth. So you have the defendant, agreeing with all the basic anatomy, agreeing with all the medicine and the risk, and basically agreeing with everything right up to the point in time where he says he didn't do anything wrong.
Just a coincidence.
Yeah, exactly.
So just to be clear, though, when you call the defense, you get to question them, but the defense lawyer does not get to question their witness?
Typically not. I mean, sometimes there might be an exception and the judge has discretion, but typically not. Now the other defense lawyers who have co-defendants can do soft crosses, and do cross-exam, which really isn't a cross-exam at all. It's just reinforcing their themes. And if they have a unified defense, then the other defense lawyers will ask questions to try and bolster the defense. So there's a lot of tactics involved in this, but you get to go first as the plaintiff's lawyer. And when you're picking your witnesses, you want to pick somebody who's going to have impact, right out of the box. I've heard, I don't know if I totally agree with this, but I've heard lawyers talk about how, you win your case in the cross-examination of the defendants, you lose your case in the direct examination and cross-examination of the experts. The experts are necessary to, prove the elements that you have to prove, but with rare exception, the jurors look at as the experts as washing each other out, canceling each other out, but it's really how the defendant performs and or testifies that that can impact the case.
As far as when do you typically, if your plaintiff is alive, and like in the CRPS case, where does the sequencing of the plaintiff come in typically?
That's a good question. I'll usually, a lot of it depends on the plaintiff. How powerful of a witness they are. But I'll typically put the plaintiff at the end of the case, or towards the end of the case. If it's a husband and wife, I might, and maybe the wife was the one who's injured, I might have the husband go before her so that he can talk about her damages, because you really don't want you don't want to rely on your plaintiff to be the source of the damages. We hear about jurors might consider them whiners. I don't know if that's totally true, but I do think it's a lot more powerful when people who are not connected directly with your plaintiff can talk about how their injuries have impacted them. Whether it's their loss of enjoyment of life, whatever it might be. But to answer your question, I'll usually put the plaintiff at the end of the case, or at least towards the end of the case.
Now let's move to cross-examination of, and I don't know how much of the case is left by the time you're done with, your case in chief and calling all these witnesses, but especially probably in reference to the defense medical experts. How do you approach that?
A lot of it just depends on the expert. I start off before ever getting to court doing as much research as I can on the defense experts. In this age of podcasting, as you know, as we're sitting here podcasting, a lot of doctors are out there podcasting and putting a lot of content out. We had a major moment in one of our medical malpractice cases a year or so ago where I cross-examined a defense expert, and he had given a podcast taking the exact opposite position than the one he was offering in our case. And it's one of the few, it's the only time I remember where after we played the podcast to the witness and in his own voice resonating, saying the complete opposite of what he had said just moments earlier, the witness goes, "Well, can I explain? I can explain." And I just ended it and said, "Well, no further questions." I mean, his credibility was down the tubes. Defense lawyer gets up and says, "Oh, yeah, you can explain. Certainly, doctor, explain, why you just, said the opposite." "Well, this was different." And he starts explaining. The jury literally turned their chairs away from the doctor. I've never seen this before. They turned their backs to him. We have swivel chairs in this particular courthouse. They turned their backs to him, crossed their arms, and would not even look at him as he tried to explain. So yeah, that's a fun example of when hard work and luck kind of join up. But to answer your question, so yes, I do a lot of research. I spend a lot of time on the internet just poking around, see what I can find, reading their articles, reading their prior depositions. So it starts with preparation. Now, as far as how I present myself in cross, some lawyers are more aggressive in terms of tone and voice, and there's a role for that sometimes, but my default is different. My default is, can't we reason together? Let's just all reason together. So with a hostile defense expert, I'll spend the first part of cross-examination talking about all the areas where we agree, and get them on I call it the yes train, try to get them on the yes train, just agreeing with me, and then give them an opportunities to explain. If anybody's old enough to remember the law professor who taught his 10 Commandments of cross-examination, I don't follow any of them. I think it may have applied at a different age, but not anymore. And I let the witness explain things. I show courtesy. I try to show courtesy at all times with the witness. And so my general approach is to be reasonable, appear reasonable, accommodating, but persistent. And if they try to dodge a question, I don't say, "Well, would you answer the question?" I'll say, well, doctor, hold on to my question. I think you're answering a little bit different than I meant to ask. So let me try to ask my question again, and really hold on to it. And if they try to dodge again, let them dodge again and say, doctor, I don't mean to, press on this forever, but it's real important I get an answer to my question. But you say it in sort of a tone. I try to say it in a tone of urgency, but also civility, and not try to be bullying. Because the jury, if when by the third or fourth time they hear the evasion, and this has taken some adjustment on my approach, I'll say, well, doctor, have you given us the best answer that you're willing to give today? I mean, what are they going to say? They say yes, we can all move on. The jury gets it. What I've changed is I used to just never give up until I got the answer, and that can be a turn off to the jury. It's like, okay, we get it, just move on. That you're driving us nuts now. So try to give them 3 or 4 opportunities, and then use white space in the courtroom. I know we've talked about this. Silence is so much more powerful sometimes. But just after he answers for the 4th time with the same evasion, just be quiet. Maybe look over at the jury. Maybe exchange a head nod, and then move on. So,
Yeah, I think you talk about being civility. It's like the emotion, because in my TLU skills boot camps that we do, and we're going to be doing them down in Huntington Beach. I hope you'll stop by and check out a little bit of it with Lloyd.
absolutely.
Some of your free time, we're doing these workshops there, but one of them is on cross-examination. And what we teach on cross-examination is, it's like I'm trying to teach the fundamentals, which I think some of them are very simple, like leading questions only, 1 new fact per question. But, obviously there's exceptions when you ask them to explain, but then you're prepared. But, but cross-examining in the present tense, not many people do that. Or, intentionally looping established facts. That's something you have to think about ahead of time. The repetition of a fact, dropping the taglines like correct, right, isn't it true? Dropping all those fillers that most people have, like the ands, the ums, the so's, because they can't handle the silence. Effectively using a flip chart to anchor your points. But another one is to really be mindful and control of your emotional state in cross. And I see so many lawyers, and it's good lawyers, experienced, as soon as they say cross, even if it's in this, whoa, knocked over my speak, but I just wanted to show you, like, even it's like here, and I call this, like, I'm trying to get it here so you can see it. That's what I call, my dojo where we train here. But the guy gets up, just like, as I'm like, I'm like, you're asking something like, what is your name? And it's like this aggressiveness. But I think that the right emotional tone for this foundational cross, the stuff we agree on, is like the inquisitive one, like, doctor, you're board certified. I mean, like, I'm just curious. We're all curious, just laying the foundation. But then when you get to the stuff where they, the clear impeachments or the, stuff that they messed up, I think that the best, instead of getting angry, because I was listening to this lawyer speak down in Cabo, there was a conference down there, and this lawyer was talking about there's an angry cross if the jury gives you permission. And I was like, I said to him afterwards, I'm like, I don't mean to disagree with you, but I would suggest you rethink this angry stuff, because I don't really see how it's helpful. I mean, wouldn't the emotion of disappointment be much more appropriate that this doctor, took an oath to help people, started out wanting to help people, but he sold himself out for money to the defense, and now he can't go back. And so he has to continue to live with this yoke around his neck and tell these lies in order to, keep feeding his family. And, isn't it sad and disappointing? I just think that's such a much more effective and tone that the jury can connect with.
Yeah, you're exactly right, Dan. And you made me think about another point, which is important, is that you can't deliver the emotion that you want the jury to feel. And a lot of lawyers try to sort of mirror the emotion that they want the jurors to have. So if they want the jury to be angry, they act angry. If they want the jury to be sad, the lawyer, lowers their voice in a very tremulous, sad, melancholy way. I think the much better approach is the civil approach, and we've got a job to do, and I need answers to my questions, I need direct answers. And when you're not going to do that, I'm going to be persistent and expose your deceptiveness. And one thing that's very powerful that we use with that I'll use with defense experts is I'll emphasize their ethical rules from their whatever organization they're associated with, like the AMA, that or the American Association of Neurologic Surgeons. They have very specific ethical rules on how to testify, and it tells them that they have to be neutral. They cannot be an advocate. They have to honestly deliver the facts. So it can be very effective early in a cross-examination to remind them of these rules and get ground rules in place. And doctor, will you agree that if I ask a question, even if you think the answer is not going to be helpful to the folks who've hired you to get involved in this case, will you agree to give that honest answer, even if it might have a negative impact on the defense? And you get those early commitments, and then you get further into cross-examination, and when they do start becoming clear advocates and they're avoiding someone, doctor, you remember we had an agreement. We were all, just about 30 minutes ago, we all had an agreement that, you and I had an agreement that you would not be an advocate. And I mean, you don't want to be argumentative with them, but just to remind the jury, and then you'll see the jury nodding their heads. It's like, and then it'll also sort of serve as a choke chain for the expert. He's not going to be called out like that again. So hopefully that'll keep the expert more on track. So they're little, preloading, front loading, but tactics that can be used. Because nobody, even experts, don't want to be humiliated on the stand. Sometimes that happens, based on their own conduct.
And then if people want to, and I just recalled back, just sit here, the webinar we did with Roger Dodd, where he analyzed one of your cross-examinations. We went through it, for a couple hours. I thought that those kinds.
That was special. I love Roger. I think he's just a fantastic lawyer and teacher and author, and he's had a big impact on my development as a lawyer.
Yeah, every day after, when I was back 30, I think it was 30 years ago, because I've been so long, or 29, but after going to work all day, I would go to the coffee shop with my book, Cross-Examination, Science-Based Technique, and read for like an hour and a half. And I think I read that book 3 or 4 times over the course of like 4 or 5 years. I'd sit down and read it, then I'd go, as a criminal defense lawyer, so I was going to try, half a dozen cases, get in there trying to figure out what the hell's going on, because like nobody's mentoring in that world. Like, I mean, the lack of mentors, but now it's such a different world. I mean, I just think that the ability to learn this is like the greatest time ever if you want to be a trial lawyer.
You're right. I mean, there's no question about it. I mean, these resources were not available, in the 90s when I was coming out, or in even the early 2000s. I mean, this is, it's. I was talking with my son, my oldest son, the other day, and commenting that there was never a point in life where they did not have the internet. And I talked to him about, I remember as clearly as yesterday that the moment where somebody showed me how the internet worked. This is 95, maybe 94, 95. And, it's all these tools just weren't available. And these resources and the online teaching, of course, you provide so many video resources. Courtroom Video Network is another good one to actually watch live trials. And you and I have talked about doing some work this next year of inviting folks to come to a trial, one of my trials, and sort of function as focus or as ghost jurors, but also have some trial exposure, because it's just hard to get into court nowadays.
Oh, we're gonna do that. We're gonna that's in the works. I just have to. I got 10 days till Huntington Beach. I'm a little bit
one thing at a time.
And then 4 months until Vegas. But once Vegas is done, that's why I like not having anything between October and June. So I have that 8 months to just kind of refocus, work on cases, really put all the stuff I've learned into practice, work, kind of do a lot of coaching stuff that I really enjoy. And so, I was just like, I mean, like even the beginning of the pandemic compared to where we are today, it's just because it's like the TLU on demand, because I watch it a lot. Obviously I've done most of the programs, but I still look back and I watch them when I'm like down the treadmill, and just like to be able to just have it right on my phone and to learn about whatever the heck a person's teaching with such perspective. And it's so much different than a book, because a book is like you just can't do anything else, and you have to be steady. And this advocacy trial lawyering is not reading; it's performing. It's being up there. It's talking. It's not just the words. It's the emotion. It's the pacing. It's delivery. All these things that
Right.
you just can't get from a book.
Right. I mean, I read a lot of the trial guides books. Right now, I'm reading Pat Malone's The Fearless Cross-Examiner, which is just excellent. So there's a role. I mean, you need to be a reader in this business because there's just things you have to know, and you can't access passively or just by watching. But you're right. You can't be a successful trial lawyer just by reading. You got to be on your feet. You've got to be willing to be criticized and be able to take criticism. And that's a lesson I talk a lot about, is just you have to really not listen to your own press too much. And when you have good results, go around with your chest out about how great of a trial lawyer you are, because you're one case away from a defense verdict. I mean, you just can't look at yourself that way, and you stop learning. If you think you got everything figured out, you close yourself off to new approaches. A quick example of this: I had a focus group, not a focus group, but I was practicing opening statement 7 or 8 months ago in a case, and I get all of my staff and people, other folks around the office, to come in and sit around a big conference room, and I'll do my opening statement. And I had this young intern working for me. He's going to law school in the fall, and young guy, no experience. And I finished my opening, and we were going around getting people's feedback on different parts. And he tells me, he goes, "Well, I just didn't think this particular component worked. It didn't really make sense." And I mean, I'm going to be honest. I had this little moment of surge saying,
Yeah,
"Who the hell are you, man?
yeah.
I mean, what do you know?" I know. And this 22-year-old kid who just graduated from college, and I had a moment of that. But I bet
I know one thought you had was, who gave you permission to speak?
exactly.
You didn't say it, but I know it was your thought.
Well, and then it was followed quickly by admiration that, first of all, that he was right on his point, and I acknowledged that, but he had the guts to speak up. I would not have had those guts my first job if I was, talking to a person who'd been out 30 years doing this kind of work. But that's the kind of thing I'm talking about. I mean, but juries are going to be hearing this for the first time. He's probably the best example of what a jury would be like, and his point was good. But a lot of lawyers, it doesn't come easy, to take criticism. We're all kind of fragile egos in some way or another, but you really got to be open to it, no matter what the source. You consider it. You may not agree with it, and you can discard it, but you should. If somebody's willing to take the time to listen to you in some component or some capacity and give you their opinion, you should honor that and appreciate it, even if you think they're wrong or on whatever the point is. So, hard lessons.
Funny you say that, because like when the boot camp stuff that we teach, sometimes people sign up for it. I don't know what they think they're signing up for. A pat on the back or something but it's like, because there's a lot of preparation, there's a lot of repetition, there's a lot of training. People have to videotape themselves, and we meet once a week and record, and I critique them and have them get up and practice on the Zoom so they can start to get the muscle memory and the movements right and control their, even practicing having a warm face. These people go like, they get this weird face, and I'm like, what the fuck is that? You know what I mean?
The Joker
weird.
face.
Right. It's so forced. I'm like, because, when we start to try to intentionally make unconscious processes conscious, it takes work, and it looks weird and it feels weird at first, and people are like, "Oh, this feels weird." Of course it feels weird. It's the first time you ever done it. How's it not going to feel weird? I mean, you're intentionally trying to do something that you never even thought of, doing, like smiling. We don't think about, oh, I want to smile, put myself in a better mood, or I want to affect the mood of the person I'm talking to. No, it's like, oh, if we're in a good mood, it shows. If we're not, then we're like, but instead of being intentional with our emotions, something that, that people have to think about and have to be mindful of. Like, what is your face saying to that jury? Because they're staring at it the whole time.
I think the best sort of analogy of what we do or what we're trying to do in court is similar to what the actor is trying to do on stage or in the movies. The actor is not pretending to be, whatever the character is. I mean, they're not focused on, pretending to be that actor. What they're doing is they're trying to reveal the truth of that character, and they're trying to make themselves a canvas to reveal and express the truth of the character, of the moment, of the scene. And they say practice things like improv and being present and being a good listener and being respectful of the audience and very conscious of who else is in the scene and working together. And I know that's very much what we're trying to do as trial lawyers. We're not because it seems like a conflict. We're told by one group, you're trying to be your authentic self. You've got to be yourself. You got to be authentic. Oh, as you're trying to be authentic, here are all these ways to carry yourself and to use your hands and your voice and where to stand in the courtroom, which is all very calculated and inauthentic. So you have this seeming conflict, but it's really not a conflict. What you're really trying to do is make yourself a better messenger or a better canvas to express the truth of the case. And there can be different truths. There can be the truth of your client's story, but they can be the truth of the defense story or the truth of a witness. And you're trying to reveal the truth of a defense witness who's just not credible and is a hired gun. So that helped me reconcile that conflict somewhat. That we're really trying to be better actors in the best sense of the word.
Well, I think trial is performance, and I've had a chance to, sit my butt in a chair like this one for the last 4 years and study the greatest trial lawyers in the country, through CVN, but also through, breaking down trials and these podcasts too. So it's really put me in a unique, I feel, like learning position. And, people say, oh, you got to be yourself. You got to be authentic. Well, that's a result of work, right?
Right.
The work is to prepare both your, in trial lawyering it's like being an NFL quarterback. You have to have the plays. You have to know what the defense is doing. You have to know what you're going to be doing, where your, receivers are going to be running, where the blockers are going to go, and where the handoff is. But you also have to get out there and practice, with the ball, practice with the pads on, practice in full speed, get as close to a game-like simulation as possible. So when the game comes, that the pressure of it, your body's ready for it.
Yeah.
And so you can be relaxed, because being authentic is really about being relaxed wherever you are, no matter what's going on around you. That allows you to be yourself. But that courtroom's so full of pressure that it's crazy how much pressure it's in there.
Yeah.
And you walk in, you just feel it. It's weird, even if you just sit there all day as a second chair and don't even do any witnesses, by the end of the day, you're exhausted, because of the mental focus and the pressure that's there. And that's why I just think that the physical, training, studying, training, the more you do, the more authentic you'll become, because you'll be confident, because you'll be relaxed.
Well, I think I would say relaxed in the right sense. I think you're right. I mean, there's an attorney out of I think he's passed away now, but he was in Vietnam. And then he came back and went to law school. He's a trial lawyer down in Florida, and he said, I remember reading this in an article he wrote. He said that the experience in a courtroom is the closest experience to being in combat that you can be. He said, in terms of the isolation, the focus, the heightened awareness, the sense of vulnerability, and the literally the other side trying to cause you harm, and that all those emotions kind of wrapped up. He says very similar, or as similar as you can be in combat, where you're not actually, at risk of having, getting shot, blown up or something. But the other point you made me think about was, the importance of training, because the more you train in discrete tasks, the less cognitive load you carry for that task. So if if you practice jury selection and practice the types of questions and get comfortable asking them, then then you have the freedom to improvise. You have the freedom to express yourself in different ways because you're not having to exert cognitive effort to handle the smaller parts of your trial. So just another way of saying I totally agree with you. I mean, practice is huge, but it has to be the correct kind of practice, coached practice. It can't be you just practicing the wrong drills over and over. You'll just be very good at doing it the wrong way. So that's a piece of it.
Goes out to the driving range, but never takes a lesson, but thinks that they're going to be getting better at golf. A person who wants to learn to play golf, but instead of going to get a coach and, have that coach design a lesson plan and then go and practice and then come back and get more coaching and adjustments on their swing and stuff, they say, I'm just going to read a book by Tiger Woods and maybe, watch a movie about, Arnold Palmer. And then I'm just going to join a country club and go tee off. And it's like, what world do you think you're living in that you're going to actually learn a skill in that way?
Yeah, it's just not how humans are. We have to practice, and actors rehearse. We have to rehearse. That's just another form of practice. But they don't. It's just not rehearsing the actual scene, but there's the pieces that go into it, the diction or the memorization of your lines or your the way you carry yourself physically. All those things go into it. And we're always learning. I'm always learning, and I'm always we're our own worst critic. And I have a really hard time watching my trials back on CVN because I'm like, oh God, why am I doing this? Why did I do that? And
we have to set up a time to do that because we were supposed to do that. We're going to watch some of your opening back. We got some time. Maybe we should do it live in Huntington Beach. And then that way we'll call it high performance coaching. You're saying we got to be coached. Let's talk about what we could have done better in this case here.
Yeah, this sounds like it may be similar to the roast of Tom Brady, where you just stand there and just throw insults at me for 2 hours. That can take it.
I heard that as a good show. I got to watch that. People said it was very politically incorrect, but very entertaining.
I mean, the whole concept of a roast of sitting there attacking somebody. I mean, I watched it. I thought it was pretty funny, but a lot of it was really cruel and hateful. But anyway, that's a different topic.
That's definitely a different topic.
Yeah.
So let's closing argument, Lloyd. Give us your take on it. I know you're got to be a pretty solid closer based upon results.
Well, I mean, the short version is, the way I think about it is, opening statement is the story of the case, and closing argument is the story of the trial. And we've all just we've had a collective experience. The jury, the jury, and the lawyers, the client, everybody in the courtroom, and what have we just experienced? So that's kind of the way I think about closing. What you don't want to do is you don't want to just repeat the story that they've already heard. What you want to do is talk about the story that's been revealed in the case. And there's a lot of rhetorical questions. What have we learned about this, that, or the other? So another key part of closing is to empower the jurors with the law. So I do a lot of teaching of the jury instructions, particularly in medical malpractice cases where you can have different standards of proof if it's involves emergency medical care, and there are other considerations. But the jury is, and I've seen this time and again, the jury is going to try and do the right thing, and they're going to try and reach the right results as they see it. And the primary tool they have is the jury instructions. So it's critical that you own those jury instructions and you teach it in a way that's memorable. I try to use demonstratives in closing to help teach the jury instructions. So for example, I'll use a set of dominoes to teach causation, and I'll pull out a set of dominoes sometimes and stack the dominoes up in front of the jury and show, here's act 1, 2, 3, this led to 4, 5, 6, down to number 10, which is the bad outcome, and then push the dominoes over in front of the jury, and the dominoes will splay out across the jury bench, and to show what causation means. And if this didn't happen but for this domino, then we never get to this bad outcome. If only this had happened. So that's one example. Scales of justice is a good one for showing preponderance of the evidence, tipping the scales. Sometimes I'll bring a real set of scales in to visually anchor that concept. So the jury instructions are very big, and then I will remind the jury and try to go with what we've learned from the evidence, from the witnesses. And I use the flip chart as well. With each witness, I'll put the witness's name at the top, and then I'll collect the key points of their testimony from the flip chart. And then at the end of each trial, I'll have my assistant take a picture on their iPhone of the flip chart page for each witness, upload that onto our system, and then in closing argument, I'll have a picture of the witness, ideally a picture taken while they're on the stand. If the trial's being videotaped, I'll take a screen capture so they can see exactly who the witness was and remember that. Then I'll have the picture on the slide next to the picture of the flip chart, and having those 3 points, and then I'll reinforce those with the jury. And then what I'm trying to do is have the jury mirror what I'm showing them in their own notes, so that they're writing down the order of proof in their notes the way that I've presented it. So those are some of the ways I'll present it. And then that's sort of phase one. And then the defense goes, then we have a phase two. We don't have to do pure rebuttal in Georgia. We don't have to. We can talk about damages for the first time in phase two. We're not limited to what the defense says in their closing. So that gives us a big advantage as well. So, because then we can talk about our damages without rebuttal. And then phase two first part is a brief rebuttal of the defense points, but I try not to do too much of that because, you can get carried down some rabbit holes. But then the bulk of phase two is all about damages charges, teaching pain and suffering, visualizing these concepts, and then of course asking for the money.
I know a lot of your trials are videoed. Do you use video clips in your closing?
I have done that before. The defense objected, but the judge allowed me to do it in one particular trial. It turned out to be a mistrial. We got it settled later, but yeah, we were capturing CVN's live feed. They were doing live feed, and I had somebody assigned back at the office to video capture that, and then I used clips from the defendant's opening statement in my closing argument. And you would have thought I'd stuck him with a hot poker. He hated that because he'd said things in opening that turned out not to be true. And I thought that was fair game to point that out. And the defense lawyer just was on his feet. The only objection he could think of was that this was inappropriate. And I said, there's no legal objection to it. This is what he said. Why is it harmful? I mean, I could tell the jury what he said, but isn't it more credible to let the jury be reminded of what he said exactly? And anyway, word got around that I was doing that. And then the defense started objecting to CVN being there in live, if they were going to live stream where I could screen capture. So it just depends. But yeah, if I can do it, I think it's very powerful. Now we're allowed to use clips of the defendants. We're allowed to use their deposition for any purpose. So I interpret that and argue that means video clips as well. So I'll try to use video clips in opening statement. Not long, because I want to keep it under 90 seconds in total, but just have a couple of clips so they can see the defendant making the point that's important. So.
All right. Well,
That's
Claggett uses them all the time, and I think it's pretty effective. And he juxtaposes the nonsense they're saying in an opening to the actual evidence they all saw in trial, or some of the witnesses.
I think it's powerful. If you can do it, I think it's great. We're visual people. Most of our jurors get all their news looking at a tablet, looking at a phone, computer. Why wouldn't we try and align our teaching to the way they learn? And that's why I roll in a big TV, 55-inch flat screen TV. I use it for my slide deck. I use it to present evidence. And if it's worth saying, it's worth presenting or worth showing. And this isn't new, but it's good to have it be reminded of it, how important it is just to be always thinking in visual terms when you're trying to teach things to the jury.
And referring back to Huntington Beach, a lot of your friends are coming that you don't even know are coming someday. This guy named Ed Bell out of South Carolina.
I do know Ed. He's going to be out there.
Yeah, he's making his debut with John Romano. They're coming from Hawaii because Western Trial Lawyers is like right before this, which I normally be at. But there's only so many weekends that are appropriate to do conferences in June, and this happens to be one of them that we both decided was appropriate. So, but I have never met him before. I talked to him.
He's great. Yeah, he's great. He's been doing a lot of work on the Camp Lejeune mass tort cases, but he's done so much great work, and he's not in an easy venue. He's over in South Carolina, and that is not an easy place to, particularly for medical malpractice cases. But yeah, I'm glad to hear he's going to be out there. That's great, and Romano too. Yeah, John's great.
Romano and your other friends from the inner circle like Del Gallipo.
Good.
He's doing his civil rights. That guy he's most amazing. I just did a podcast with him yesterday, so I'll be coming out some. But he's just such an interesting, amazing person. He
really is. I mean, he's doing the hardest cases in the world, these civil rights, police brutality cases, and he just routinely gets 7-8-figure verdicts. And I mean, I don't want to speak for Dale, but one thing he told me one time that just impressed me is he said, I don't present myself as anti-cop. I'm not hostile towards law enforcement. I'm anti-bad cop. And I'm anti-cops who break the rules and don't respect people's civil rights and use excessive force. And it's similar in medical cases. I'm not anti-doctor. And I'll say that to the jury. I have tremendous respect for the medical community in medicine that's practiced correctly, with patient safety and patient care being the most important priorities. But I am very hostile towards doctors putting their or hospitals putting their bottom line ahead of patient safety and cutting resources and not providing the medical providers the resources they need to deliver good care. And we all see it. We know it. When you go to the emergency room, you probably won't even see a doctor. You'll see a nurse practitioner or a PA. They're not doctors. They didn't go to medical school, that kind of thing. There's a lot of overlap.
Yeah, it's going to be, we're going to see each other about 10 days, Lloyd. Actually, probably, 12 days now. We got a little holiday weekend coming up here. So I'm sure you're going out to the lake house for the holiday, I'm sure?
I am. I'm going to spend the weekend out there. The water's warm now, so it's I'll be in the water a little bit. But also I've got a big trial starting the first week of August, and I'll be spending some time getting my head around some of the things we need to do for that trial. But looking forward to Huntington. Dan, thanks for inviting me on your podcast and included me on this program. I'm real excited about it, and I'm looking forward to seeing some friends and talking about medical malpractice. It's going to be a good time.
Seeing everybody.
Yeah.
And
friends and enemies.
Friends and enemies. So many great lawyers are coming.
No enemies
Nick
out there.
Rowley's trial got continued that he was doing with Rick Friedman. And so he'll be coming out and teaching them. He's going to come out for a couple of days. He's going to host, you're going to host an hour with 3 lawyers that got significant verdicts over the last year. And, I'm talking about how they did it. So he's going to do that with, 3 folks on
Excellent.
Friday afternoon. And I think that should be fun for everybody. And I'm just so looking forward to this event. I can't even tell you. Having trouble sleeping for the next 12 days. But thanks for coming on, Lloyd. Good seeing you as always.
Thanks, Dan. I appreciate it.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.